Hi friends, this is Ashutosh Jha, Director of the Migration Bureau, and we are back with a new video. I have been getting a lot of queries and many of you have been asking me that what happens in a scenario where a foreigner who got his work visa joins his work and does not feel comfortable with the working environment or is homesick. So what is the legal procedure for the cancellation and the termination of his employment contract? So this is the topic of our video today: how to cancel or terminate your employment contract in Poland. So without any further ado, let's get started. There are three methods of terminating employment agreement in Poland, and they are termination by mutual consent, termination with notice, and lastly, termination without notice. There will be no repercussions if you terminate your employment contract with notice or by mutual consent. But termination without notice is something that we should discuss in details. An employee may terminate his employment agreement without notice if he received a medical certificate declaring a harmful effect of the work performed on the health of the employee and the employer within the period determined in the medical certificate fails to transfer the employee to another position appropriate for his health condition and corresponding to his professional qualifications. In the event of severe violation of employer's basic duties, in such case the employee is entitled to compensation in the amount of remuneration for the notice period. An employer may terminate the employment agreement without notice in the event of a severe violation by the employee of the employee's basic duties. If the employee commits an offense which prevents further employment in the occupied job position, if the offense is obvious or has been declared by a final court sentence. If the employee, through his fault, loses a license required to perform work in the occupied job position. If an employee is unable to work as a result of an illness for more than 3 months, if the employee has been employed with a given employer for less than 6 months, for longer than the period of receiving remuneration and welfare and sickness benefits on that account, as well as receiving rehabilitation allowance for the first 3 months, if the employee has been employed with a given employer for at least 6 months, or if the incapacity to work was caused by an accident at work or an occupational disease. If an employee has any justifiable absence from work for other than aforementioned reasons lasting for more than 1 month. The employment agreement can be terminated by notice given by each party. The time duration of the notice depends on the length of the employment. The notice period, depending on definite and indefinite contract of employment, are 2 weeks if the employee was employed for less than 6 months, 1 month if the employee was employed for at least 6 months, 3 months if the employee was employed for at least 3 years. In case of agreement for indefinite period, the employer's notice of termination should state the reason justifying the termination. The law in Poland does not provide the list of possible reasons, but according to Polish judicature, the reason should be real, concrete, and understandable for employee. In case of agreement for trial period, the period for termination notice are 3 business days if the trial period does not exceed 2 weeks, 1 week if the trial period is longer than 2 weeks, 2 weeks if the trial period is 3 months. So friends, this brings us to the end of our video. I hope that now you have a better understanding of termination of the employment contract in Poland. If you got value out of this video, please like, comment and share the video, and for more information log on to the website which is mentioned in the link below. This is Ashutosh Jha, Director of the Migration Bureau, signing off until next time.